Welcome to this exam review from Birdsy, your AI-powered study partner. Be sure to like and subscribe for more videos. Let's get started.
Let's begin by reviewing the fundamentals of contract law. Essential elements of a valid contract: offer, acceptance, consideration, lawful purpose, competent parties. Which of the following is a necessary element for a contract to be considered valid? Is it A, consideration, B, a written document, C, a witness, or D, a notary public? The answer is A, consideration. A valid contract must include an offer, acceptance, consideration, lawful purpose, and competent parties. Without any of these elements, the contract may be void or voidable. In contract law, which element is not required for a contract to be enforceable? Is it A, offer, B, notarization, C, acceptance, or D, competent parties? The answer is B, notarization. Why this question may seem a bit tricky. The term enforceable can mislead one to think of formalities like notarization, but the core elements are offer, acceptance, consideration, lawful purpose, and competent parties. John offers to sell his car to Mary for $5,000, and Mary accepts the offer. What element is missing if Mary is only 16 years old? Is it A, offer, B, acceptance, C, competent parties, or D, consideration? The answer is C, competent parties. Mary's age affects her legal capacity to enter into a contract, making her a potentially incompetent party, which is a necessary element for a valid contract. What does consideration in contract law refer to? Is it A, the intention to create legal relations, B, the presence of a written agreement, C, the involvement of a third party, or D, something of value exchanged between parties? The answer is D, something of value exchanged between parties. Consideration refers to something of value exchanged between parties, which is a necessary element for a contract to be valid. Alice agrees to paint Bob's house for $1,000, but later decides to charge $1,500 without Bob's consent. What element of a valid contract is compromised? Is it A, consideration, B, offer, C, acceptance, or D, lawful purpose? The answer is A, consideration. The change in price without mutual agreement affects the consideration, as both parties must agree to the terms for the contract to remain valid. Which of the following is an essential element of a valid contract? Is it A, consideration, B, witnesses, C, written agreement, or D, notarization? The answer is A, consideration. A valid contract requires an offer, acceptance, consideration, lawful purpose, and competent parties. Without any of these elements, a contract may not be enforceable. In contract law, which element is often misunderstood as not being necessary for a contract to be valid? Is it A, offer, B, consideration, C, acceptance, or D, competent parties? The answer is B, consideration. Why this question may seem a bit tricky. Many assume that consideration is not necessary if there is mutual agreement. But without consideration, a contract may lack enforceability. Tom agrees to sell his bike to Jerry for $200, but later Jerry finds out Tom is only 15 years old. What element of a valid contract is potentially compromised? Is it A, offer, B, acceptance, C, competent parties, or D, consideration? The answer is C, competent parties. Tom's age may affect his legal capacity to enter into a contract, as minors typically lack the legal competence to form binding agreements.
Notice the code in the corner? When you're stumped by a question, enter it at Birdsy.ai for immediate help. Enjoy complimentary study sessions and access to hundreds of additional questions to help you pass your exam with confidence.
Classification of contracts: bilateral versus unilateral, executory versus executed, express versus implied. What is a bilateral contract? Is it A, a contract where only one party makes a promise? B, a contract where both parties exchange promises? C, a contract that has been fully performed? Or D, a contract implied by actions rather than words? The answer is B, a contract where both parties exchange promises. A bilateral contract involves mutual promises between two parties, where each party is both a promiser and a promisee. In contract law, what distinguishes an executory contract from an executed contract? Is it A, an executory contract is one that has been fully performed by both parties? B, an executed contract is one that is still in progress? C, an executory contract is one where performance is still due? Or D, an executed contract is one that is implied by actions? The answer is C. An executory contract is one where performance is still due. Why this question may seem a bit tricky: the terms executory and executed sound similar, but refer to different stages of contract performance. Alice agrees to mow Bob's lawn in exchange for $50, and Bob agrees to pay her after the job is done. What type of contract is this? Is it A, bilateral contract, B, unilateral contract, C, executed contract, or D, implied contract? The answer is A, bilateral contract. This is a bilateral contract because both parties have made promises to each other. What is an express contract? Is it A, a contract with terms explicitly stated, B, a contract formed by actions rather than words, C, a contract that is fully performed, or D, a contract where only one party makes a promise? The answer is A, a contract with terms explicitly stated. An express contract is one where the terms are clearly stated, either orally or in writing. John orders a meal at a restaurant and eats it without discussing payment terms. What type of contract is this likely to be? Is it A, bilateral contract, B, unilateral contract, C, executed contract, or D, implied contract? The answer is D, implied contract. This is an implied contract, as the agreement is inferred from the actions of the parties. Sarah offers to pay Tom $100 if he paints her fence by the end of the week. Tom paints the fence and Sarah pays him. What type of contract is this? Is it A, bilateral executory, B, bilateral executed, C, unilateral executed, or D, unilateral executory? The answer is C, unilateral executed. This is a unilateral contract because Sarah made a promise that Tom accepted by performing the act of painting the fence.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Enforceability: valid, void, voidable, unenforceable, statute of frauds, when writing is required. Which of the following contracts is considered void? Is it A, a contract with a minor, B, a contract for an illegal purpose, C, a contract under duress, or D, a contract lacking consideration? The answer is B, a contract for an illegal purpose. A contract for an illegal purpose is void because it lacks legal enforceability from the outset. It cannot be ratified or enforced by either party. Why might a contract be considered unenforceable under the statute of frauds? Is it A, it involves a minor, B, it lacks mutual consent, C, it is not in writing, or D, it was made under duress? The answer is C, it is not in writing. Why this question may seem a bit tricky, the statute of frauds requires certain contracts to be in writing to be enforceable, such as those involving real estate or agreements that cannot be performed within a year. John agrees to sell his house to Mary, but they only have a verbal agreement. What is the status of this contract under the statute of frauds? Is it A, valid and enforceable, B, void, C, voidable, or D, unenforceable? The answer is D, unenforceable. Real estate contracts must be in writing to be enforceable under the statute of frauds. A verbal agreement for the sale of a house is unenforceable. If a contract is voidable, what does this mean for the parties involved? Is it A, one party can choose to void the contract, B, the contract is automatically void, C, the contract is enforceable by both parties, or D, the contract is illegal? The answer is A, one party can choose to void the contract. A voidable contract is valid until one party chooses to void it. This typically occurs due to factors like misrepresentation or duress. Sarah signs a contract under the belief that it is a gift, but it is actually a loan agreement. What is the status of this contract? Is it A, valid and enforceable, B, voidable, C, void, or D, unenforceable? The answer is B, voidable. Why this question may seem a bit tricky, misunderstanding the nature of a contract can make it voidable due to misrepresentation, allowing Sarah to void it. Emily verbally agrees to lease her apartment to Tom for 2 years. After a year, Tom decides to move out and stop paying rent. What is the enforceability of their agreement under the statute of frauds? Is it A, the agreement is valid and enforceable, B, the agreement is void, C, the agreement is unenforceable, or D, the agreement is voidable? The answer is C, the agreement is unenforceable. The statute of frauds requires leases longer than 1 year to be in writing to be enforceable. Since Emily and Tom's agreement was verbal, it is unenforceable. Real estate-specific contracts. Purchase agreements/offers, terms, acceptance, counteroffers, revocation, deadlines, time is of the essence. What does the term time is of the essence imply in a real estate purchase agreement? Is it A, deadlines in the contract are strict and must be adhered to, B, the contract can be extended if both parties agree, C, the buyer has the right to delay the closing date, or D, the seller can revoke the offer at any time? The answer is A, deadlines in the contract are strict and must be adhered to. The phrase time is of the essence means that all deadlines in the contract are strict and must be adhered to. Missing a deadline can result in a breach of contract. If a buyer submits an offer with a deadline for acceptance, what happens if the seller responds after the deadline? Is it A, the original offer is automatically accepted, B, the original offer is still valid, C, the seller's response is a counteroffer, or D, the buyer must accept the late response? The answer is C, the seller's response is a counteroffer. Why this question may seem a bit tricky, the seller's late response is considered a counteroffer, not an acceptance, because the original offer expired. John submits an offer to purchase a house, but the seller counters with a higher price. John accepts the counteroffer, but later decides to revoke his acceptance. What is the status of the contract? Is it A, the original offer is reinstated, B, A binding contract exists at the counteroffer terms. C. John can revoke his acceptance without penalty. Or D. The seller must accept John's revocation not. The answer is B. A binding contract exists at the counteroffer terms. Once John accepted the counteroffer, a binding contract was formed. Revocation is not possible without mutual agreement. What is a counteroffer in the context of real estate transactions? Is it A. An agreement to all terms of the original offer? B. A withdrawal of the original offer? C. An unconditional acceptance of the offer? Or D. A response that alters the terms of the original offer? The answer is D. A response that alters the terms of the original offer. A counteroffer is a response to an offer in which the original terms are altered, effectively rejecting the initial offer. Emily receives an offer on her property with a time is of the essence clause. She wants to accept, but misses the deadline by 1 day. What is the status of the offer? Is it A. The offer is automatically accepted? B. The offer has expired and is no longer valid? C. Emily can still accept the offer without any issues? Or D. The buyer must honor the original offer? The answer is B. The offer has expired and is no longer valid. Emily's acceptance after the deadline is ineffective, and the offer has expired. She can propose a new offer or counteroffer. In a real estate purchase agreement, what happens if a buyer revokes their offer before the seller accepts it? Is it A. The offer remains valid until the original expiration date? B. The offer is canceled and no longer valid? C. The seller can still accept the offer within a reasonable time? Or D. The buyer must wait for the seller's response before revoking? The answer is B. The offer is canceled and no longer valid. A buyer can revoke their offer any time before the seller accepts it, effectively canceling the offer without any legal consequences. Sarah submits an offer to buy a house with a time is of the essence clause, but the seller counters with a different closing date. What is the status of the original offer? Is it A. The original offer remains valid until Sarah responds? B. The original offer is automatically accepted with the new terms? C. The original offer is terminated by the counteroffer? Or D. The original offer is on hold until Sarah decides? The answer is C. The original offer is terminated by the counteroffer. The original offer is terminated when the seller makes a counteroffer, as it constitutes a rejection of the initial terms. Listing agreements and buyer-broker agreements, employment contracts, exclusive versus open listing, commission entitlement. What is the primary difference between an exclusive right-to-sell listing and an exclusive agency listing? Is it A. The duration of the listing agreement? B. Who is entitled to a commission if the owner sells the property? C. The type of property being sold? Or D. The requirement for the broker to advertise the property? The answer is B. Who is entitled to a commission if the owner sells the property? An exclusive right-to-sell listing guarantees the broker a commission regardless of who sells the property, while an exclusive agency listing allows the owner to sell without owing a commission. In a buyer-broker agreement, who is typically responsible for paying the broker's commission? Is it A. The buyer always pays the commission? B. The broker pays themselves from their own funds? C. The seller usually pays the commission through the listing broker, ... Or D. The commission is waived in a buyer-broker agreement? The answer is C. The seller usually pays the commission through the listing broker. Why this question may seem a bit tricky, the buyer-broker agreement can specify different arrangements, but typically the seller pays the commission through the listing broker. John signed an open listing agreement with multiple brokers to sell his house. If John finds a buyer himself, what is the commission situation? Is it A, John owes no commission to any broker? B, John owes a commission to the first broker he signed with? C, John must split the commission between all brokers? Or D, John owes a commission to the broker who advertised the most? The answer is A, John owes no commission to any broker. In an open listing, the owner retains the right to sell the property independently without owing a commission to any broker. What is a key characteristic of an employment contract in real estate? Is it A, it is only verbal and not written? B, it only applies to commercial properties? C, it guarantees a sale within a specific time frame? Or D, it outlines the broker's duties and compensation? The answer is D. It outlines the broker's duties and compensation. An employment contract in real estate establishes the terms under which a broker will represent a client, including duties and compensation. Samantha has an exclusive right to sell agreement with a broker, but finds a buyer herself. What is her obligation regarding commission? Is it A, Samantha owes no commission since she found the buyer? B, Samantha owes the broker a full commission? C, Samantha owes a reduced commission? Or D, Samantha can negotiate a new commission rate? The answer is B, Samantha owes the broker a full commission. In an exclusive right-to-sell agreement, the broker is entitled to a commission regardless of who finds the buyer. Options, lease options, lease purchase contracts, land contracts, contract for deed. What is a key characteristic of a land contract, also known as a contract for deed? Is it A, the buyer receives legal title immediately upon signing? B, the seller retains legal title until the buyer completes payment? C, the buyer can sell the property before completing payments? Or D, the buyer must pay the full purchase price up front? The answer is B. The seller retains legal title until the buyer completes payment. In a land contract, the seller retains legal title until the buyer completes all payment obligations, at which point the title is transferred. In a lease option agreement, what is the tenant's obligation regarding the purchase of the property? Is it A, the tenant must purchase the property at the end of the lease term? B, the tenant must decide to purchase within the first month of the lease? C, the tenant has the right, but not the obligation to purchase the property? Or D, the tenant must pay a penalty if they choose not to purchase? The answer is C. The tenant has the right, but not the obligation, to purchase the property. Why this question may seem a bit tricky. Lease option agreements give the tenant the right, but not the obligation, to purchase the property, which can be confused with lease purchase agreements where the purchase is obligatory. Sarah enters a lease purchase agreement with a seller, agreeing to buy the property after 3 years. What is Sarah's obligation at the end of a lease term? Is it A, Sarah must purchase the property as agreed? B, Sarah can choose to extend the lease without purchasing? C, Sarah can decide not to purchase without any consequences? Or D, Sarah must renegotiate the purchase terms? The answer is A, Sarah must purchase the property as agreed. In a lease purchase agreement, Sarah is obligated to buy the property at the end of the lease term, unlike a lease option where purchase is optional. John is considering a lease option contract for a property he likes. What should he be aware of regarding his rights at the end of the lease? Is it A, John must purchase the property at the end of the lease? B, John will lose his option fee if he decides to purchase? C, John can extend the lease indefinitely? Or D, John has the right to purchase the property, but it is not mandatory? The answer is D. John has the right to purchase the property, but but it is not mandatory. In a lease option, John has the right to purchase the property at the end of the lease, but he is not obligated to do so. Contract modifications, assignments, and terminations. Amendments and addenda, when contracts may be modified, assignment versus novation. What is the primary difference between an assignment and a novation in contract law? Is it A, assignment transfers rights, novation replaces a party? B, assignment requires all parties' consent, novation does not? C, assignment and novation both transfer obligations without consent? Or D, assignment replaces a party, novation transfers rights? The answer is A, assignment transfers rights, novation replaces a party. An assignment transfers rights or benefits to another party, while a novation replaces one party with another, requiring the consent of all original parties. Why might a contract modification be considered invalid? Is it A, the modification was agreed upon verbally? B, the modification was made after the contract was signed? C, the modification was not notarized? Or D, the modification lacked mutual consent? The answer is D, the modification lacked mutual consent. Why this question may seem a bit tricky. Modifications require mutual consent and consideration. A lack of either can invalidate the modification. Sarah and Tom have a contract for the sale of a car. Tom wants to transfer his obligations to Mark. What must occur for this to be a novation? Is it A, Tom must notify Sarah of the transfer? B, Mark must agree to take over the contract? C, all parties must consent to the replacement? Or D, Tom must assign his rights to Mark? The answer is C, all parties must consent to the replacement. For a novation, all parties, including Sarah, Tom, and Mark, must agree to replace Tom with Mark in the contract. In a real estate contract, when is an addendum typically used? Is it A, to replace the entire contract with new terms? B, to add additional terms to the existing contract? C, to remove terms from the existing contract? Or D, to terminate the contract entirely? The answer is B, to add additional terms to the existing contract. Why this question may seem a bit tricky. An addendum is used to add terms to an existing contract, not to replace or remove terms.
Finding this exam review helpful? If you haven't already, like and subscribe for more videos that'll get you ready to pass.
Termination, performance, expiration, mutual rescission, breach, default, specific performance. What is the legal term for ending a contract by mutual agreement of all parties involved? Is it A, specific performance? B, mutual rescission? C, breach of contract? Or D, expiration? The answer is B, mutual rescission. Mutual rescission occurs when all parties agree to terminate the contract and release each other from obligations. If a contract is terminated due to a party's failure to perform, what is this called? Is it A, mutual rescission? B, expiration? C, breach? Or D, specific performance? The answer is C, breach. Why this question may seem a bit tricky. The terms breach and default are often confused. A breach is a failure to perform, while default is a specific type of breach often related to financial obligations. John and Mary entered into a contract for the sale of a car, but John failed to deliver the car by the agreed date. What legal action can Mary pursue to enforce the contract? Is it A, mutual rescission? B, expiration? C, breach? Or D, specific performance? The answer is D, specific performance. Specific performance is a legal remedy where the court orders the breaching party to fulfill their contractual obligations, such as delivering the car. What happens when a contract naturally comes to an end after fulfilling its terms? Is it A, expiration, B, mutual rescission, C, breach, or D, specific performance? The answer is A, expiration. When a contract naturally ends after fulfilling its terms, it is said to have expired. Alice signed a contract to buy Bob's house, but Bob decided not to sell. What can Alice seek to ensure the sale goes through? Is it A, mutual rescission, B, specific performance, C, expiration, or D, breach? The answer is B, specific performance. Alice can seek specific performance, a court order compelling Bob to complete the sale as agreed in the contract. Breach, remedies, and risk management. Breach of contract, material versus minor, rights of parties. What is the primary difference between a material breach and a minor breach of contract? Is it A, a material breach allows contract termination while a minor breach does not? B, a minor breach allows contract termination while a material breach does not? C, both types of breaches allow for contract termination? Or D, neither type of breach allows for contract termination? The answer is A, a material breach allows contract termination while a minor breach does not. A material breach significantly affects the contract's outcome, allowing the non-breaching party to terminate the contract. A minor breach does not justify termination, but may allow for damages. In a contract dispute, if a party claims a breach is material, what must they demonstrate? Is it A, that the breach was intentional, B, that the breach significantly impacts the contract's purpose, C, that the breach caused financial loss, or D, that the breach was unforeseen? The answer is B, that the breach significantly impacts the contract's purpose. Why this question may seem a bit tricky, the focus is on the impact of the breach, not just the breach itself. The breach must significantly affect the contract's purpose. Alice contracts Bob to deliver goods by a specific date, but Bob delivers them a day late. Alice claims a material breach. What is likely the outcome? Is it A, Alice can terminate the contract immediately? B, Alice can claim a material breach and sue for damages? C, Alice may claim damages but not terminate the contract? Or D, Alice has no remedy available? The answer is C, Alice may claim damages but not terminate the contract. A late delivery is typically a minor breach unless time is explicitly of the essence, affecting Alice's rights to terminate. John hires a painter to complete a mural by July 1st for a grand opening event. The painter finishes on July 5th, but the mural is exactly as requested. John claims a material breach. What is likely the outcome? Is it A, John can terminate the contract and refuse payment? B, John can demand a full refund for the delay? C, John can claim damages for any losses due to the delay? Or D, John has no recourse as the mural was completed? The answer is C, John can claim damages for any losses due to the delay. A delay in performance without significant impact on the contract's purpose is typically a minor breach. The mural's completion, albeit late, fulfilled the contract's main objective. Remedies: suit for damages, rescission, reformation, specific performance, liquidated damages. Which remedy involves the court ordering a party to perform their contractual obligations as agreed? Is it A, rescission, B, reformation, C, specific performance, or D, liquidated damages? The answer is C, specific performance. Specific performance is a remedy where the court orders the breaching party to fulfill their contractual duties, typically used when monetary damages are inadequate. In a contract dispute, which remedy is most likely to be granted when the contract involves unique goods? Is it A, rescission, B, specific performance, C, reformation, or D, liquidated damages? The answer is B, specific performance. Why this question may seem a bit tricky, unique goods often make monetary damages inadequate, leading courts to favor specific performance, not rescission. Alice contracts to buy a rare painting from Bob, but Bob refuses to sell. What remedy is Alice most likely to pursue? Is it A, specific performance, B, rescission, C, reformation, or D, liquidated damages? The answer is A, specific performance. Specific performance is often sought for unique items like rare paintings, as monetary damages may not adequately compensate for the loss. Risk management for licensees, proper handling of earnest money deposits, disclosures, avoiding unauthorized practice of law. What is the primary responsibility of a licensee when handling earnest money deposits? Is it A, use it for personal expenses until closing, B, deposit it into a trust or escrow account promptly, C, hold it in a personal account until the transaction closes, or D, return it to the buyer immediately after receiving it? The answer is B, deposit it into a trust or escrow account promptly. Licensees must deposit earnest money into a trust or escrow account promptly to ensure proper handling and compliance with legal requirements. Why might a licensee's advice on contract terms be considered unauthorized practice of law? Is it A, because licensees are allowed to draft contracts, B, because licensees can interpret legal documents, C, because advising on legal terms requires a law license, or D, because licensees can only provide financial advice? The answer is C, because advising on legal terms requires a law license. Why this question may seem a bit tricky. Licensees often discuss contracts, but advising on legal terms can cross into unauthorized practice of law, which is reserved for licensed attorneys. During a transaction, Sarah, a licensee, receives earnest money from a buyer. What should she do to ensure compliance with risk management practices? Is it A, deposit the money into a designated trust account, B, keep the money in her office safe until closing, C, use the money to cover transaction-related expenses, or D, return the money to the buyer immediately? The answer is A, deposit the money into a designated trust account. Sarah should deposit the earnest money into a designated trust account to comply with legal requirements and protect the funds.
Thanks for watching. If you found this exam review helpful, be sure to subscribe for more real-world practice and topic-focused study videos. And visit Birdsy.ai to start your free trial of Birdsy, your AI-powered study partner.